Well, good morning. My name is Hillary Haynes from the Greater Bakersfield Chamber, and I'm your host for this morning's New Year update. Today's Labor Law and HR Forum is sponsored by Young Wooldridge and LeBeau Thielen. We appreciate their support because it allows the Chamber to offer these low-cost labor law and HR forums as a service to our members. I'm happy that you could join us as today as we hear from attorneys Jerry Pearson and Dan Klingenberger, who will be providing updates about some of the key changes in legislation dealing with COVID-19, expansion of the California Family Rights Act, as well as modifications to AB 5 regarding independent contractors. I emailed everyone the PowerPoint this morning, so feel free to follow along and take notes. As noted in the email, the Chamber should be receiving the shipment of labor law posters sometime next week, and we'll get those mailed out as soon as we receive those. But before we get started, I want to go over some Zoom etiquette to make these next couple of hours run smoothly. We have everyone muted to help eliminate any background noise. So if you have any questions or would like to comment, please use the Q&A for the questions and then the chat for any anything that you'd like to share. And those icons can be found on the bottom of your screen. This will notify Jerry, Dan, and I that someone has a question or comment, and then I'll go ahead and ask it out loud once I see those start popping up. So I'd like to introduce our speakers today. Jerry Pearson is a managing partner at Young Wooldridge and leads the firm's business department. Jerry is a past president of the Kern County Society for Human Resource Management's Board of Directors. And at LeBeau Thielen, Dan Klingenberger advises employers on day-to-day labor and employment law matters to develop effective and practical ways to deal with challenging employee issues. So I believe Jerry is our first speaker today.
That is correct. Thank you, Hillary. Hopefully everybody can hear me.
Yes, we can hear. I can hear you.
Great. So good morning, everyone. It's great to be back with you in 2021. Sad that we're still on Zoom, but hopefully before this year is over, we'll be back in front of you again. I really miss being in front of you face to face. It's not the same over a computer, but as Hillary mentioned, we do want this to be as interactive as possible. So we encourage questions, we encourage comments. So please, by all means, if you have a question or a comment as Dan and I go along, please submit that through the chat or the Q&A portal, and then we will address those as we go along. First, before we start, I do want to recognize and thank Dan and give him the credit for putting this outline together. I take no credit for that. He did a lot of work in doing this, so I want to make sure he's recognized for that. And the format we're going to use today is there's about, if you look at the handout, there's about 6 main sections that we're going to cover today. And so Dan and I thought the best way to do it would be to break that up. And so I'm going to take one section, such as wage and hour, and then Dan will take the next section so that you guys don't get too tired of either one of us, and we'll just hand it off that way. So let's go ahead and get started. First section being wage and hour. And I'll deal with the legislative changes that we need to deal with this year in this category of the law. So the first one we want to talk about is statute of limitations for wage and hour discrimination filings with the Labor Commissioner. Some of you who have worked in this industry for years may know that traditionally and historically, the statute of limitations for an employee to file a claim who had been discharged or otherwise discriminated against with the Labor Commissioner was 6 months. That's been changed. AB 1947 amends Labor Code 98.7, and they've extended that deadline to file a claim with the Labor Commissioner to 1 year. AB 1947 also modified Labor Code section 1102.5, which prohibits employers from making, adopting, or enforcing any policy that prevents an employee from disclosing information to a government or a law enforcement agency where the employee had reasonable cause to believe that the information disclosed violated a state or federal law. The statute also prohibits retaliation against any employee who discloses such information, refuses to participate in any activity that would result in a legal violation, whereas exercise such a right. It modified it in the sense that prior to now, 1102.5 allowed for an employee who alleged such a claim to collect damages, but not attorney's fees. So as of January 1 of this year, an employee who alleges such a violation who prevails in a claim for such allegations can now also claim attorney's fees under that code section. So, all right, moving on. Public Works. So if we have anybody here today who deals with government contracts, working on projects that are considered public works, we have a bit of a change in this law clarification under AB 1720. Previously, the code read that if the state or political subdivision reimburses a private developer for costs that would normally be borne by the public, or provides directly or indirectly public subsidy to a private development project that is de minimis, there's the key word we're dealing with today, in the context of the project, an otherwise private development project shall not thereby become subject to the requirements of this chapter. Now, this amendment tells us a little bit more about what de minimis is. It gives us a definition. So now, as of July 1, 2021, so 6 months from now, for purposes of subparagraph A, a public subsidy is de minimis if it is both less than $600,000 and less than 2% of the total project cost. Notwithstanding clause 1 above, for purposes of subparagraph A, a public subsidy for a project that consists entirely of single family dwellings is de minimis if it is less than 2% of the total project cost. And the subparagraph shall not apply to a project that was advertised for bid or a contract that was awarded prior to July 1, 2021. So as the last bullet point notes there, this may cause, probably will cause, more projects to be subject to prevailing wage laws. Next slide, please. So the previous slide and the next couple of slides are going to deal with things that are pretty narrowly tailored. The last one was for a public works project. The next couple are for security guards and folks that work in safety sensitive positions on a particular type of petroleum facility. Typically, if I was in front of you, I would say, anybody work in these lines of work, and I would have you raise your hands. I can't do that today. I don't know. So I might have 15 people who work in these lines of work in these industries. So I'm going to cover it like everybody in the room is subject to these new provisions. If anybody remembers the Augustus versus ABM Security Services case from a couple of years ago, actually, as you can see on the slide, 4 years ago now, it doesn't seem like it was that long ago, but that dealt with rest breaks particular to security guards. And it kind of sent, at that time, sent a little, actually, kind of medium-sized ripple through the defense industry about security guards, and we were afraid that might get expanded to other industries. And the issue was employees, and specifically security guards, who were not able to take a completely off-duty rest break because they were tethered to a walkie-talkie or a cell phone or some sort of device that maybe they get called back during their rest break. Well, this new labor code section 226.75 provides that persons working in certain safety sensitive positions at a very narrowly defined type of petroleum facility do not need to be relieved of all duty to qualify for a rest period. For example, they can still be expected to respond to a radio or cell phone. This exception applies only to defined petroleum facilities covered by collective bargaining agreements that provide for compensation that is at least 30% more than minimum wage. Right now, this AB 2479 extends this law through January 1, 2026. But again, this is narrowly tailored. Next slide, similar to 226.75, AB 1512 creates a special rest period rule for certain types of security guards. AB 1512 became effective September 30, 2020. In terms of its impact on litigation, however, it only applies to cases filed on or after January 1, 2021. The statute is to remain in effect through January 1, 2027. And it adds new Labor Code Section 226.7. If the conditions of the statute are met, an employer may require security guards to remain on site and on call and to monitor cell phones, radios, et cetera, during rest periods. If an employee's 10-minute rest period is interrupted, the employer must allow the employee to restart a rest period as soon as practicable. For purposes of the statute, interrupted is defined as any time a security officer is called upon to return to performing the active duties of the security officer's post prior to completing the rest period. However, here's when the statute applies. Only if the following conditions are satisfied. 1, the employer and employee must both be registered under California's Private Security Services Act. 2, the employee is covered by a valid collective bargaining agreement. And I think, I don't do a lot of work with security guards, but it's my impression, and I think the ones that I know, I think most security guards are covered by collective bargaining agreement. 3, the valid collective bargaining agreement expressly provides for the wages, hours of work, and working conditions of employees. So it's got to be under those 3 prongs. And again, so this is only for unionized security guards that meet those conditions. Okay. Moving on, another one that is very narrowly tailored here. Acute care hospitals must reimburse training expenses incurred by applicants. So if you do HR in California, you know that we already have Labor Code Section 2802, which says that California employers must indemnify or reimburse their employees for all necessary expenditures or losses incurred by the employee as a direct result of performing their duties. Okay, but AB 2588 adds Section 2802.1 to the Labor Code. It is specific to employees providing direct patient care. The new law applies to any expense or cost of any employer provided or employer required educational program or training for an employee providing direct patient care or an applicant for direct patient care and employment. AB 2588 defines employer provided or employer required educational program or training to include residencies, orientations, or competency validations necessary for direct patient care employment. So if you work in that industry, acute care hospitals, please note that in addition to 2802 in reimbursing reasonable and necessary employee expenditures, you have this new 2802.1 that you have to look at and make sure that you're complying with. Okay. All right. Moving on. This is kind of a big one. Successor liability for labor code judgments is expanded. The Labor Commissioner wants to make sure that they don't have employers that are shirking their responsibility to pay for judgments by simply disbanding, closing down, bankrupting a corporation or a company and starting a new one. Okay, so this law states that a successor to a judgment debtor shall be liable for any wages, damages, and penalties owed to any of the judgment debtor's former workforce pursuant to a final judgment after the time to appeal has expired. Okay, so successorship is established upon meeting any of the following criteria. Any of the following criteria. 1, the successor uses substantially the same facilities or substantially the same workforce to offer substantially the same services as the judgment debtor. You're the same guy, you're the same company. Just change your name, but you get the same workforce and doing the same stuff. Or 2, has substantially the same owners or managers that control the labor relations as a judgment debtor. Or 3, employees as a managing agent, any person who directly controlled the wages, hours, working conditions of the affected workforce of the judgment debtor. Or 4, operates a business in the same industry and the business has an owner, partner, officer, or director who is an immediate family member of any owner, partner, officer, or director of the judgment debtor. So, you're not going to be able to get away from a judgment from the Labor Commissioner just by starting a new shell company. Okay, that's what they're trying to do with this AB 3075. The ABC test, I'm not going to spend a lot of time on this. I know we've talked about it for, I don't know, a couple of years now, I think. So what I want to tell you is ABC test is still the law of the land, okay, under AB 5. If you think you have an exception to the ABC test, please remember that the old, what's called the Borello test or the control test still must apply. So there was some exceptions that were put into place this past year. Okay, a number of exceptions, exemptions. Okay, first of all, as you can see by this bullet point, to clarify the business-to-business exception. A lot of my clients, well, I don't know if a lot of my clients, but certainly a handful of my clients called me when AB 5 went into place and said, you know, I think it fell under the business-to-business exception. Okay, most of them did not, but there's been some clarification to the business-to-business exception. Bullet point 2, expanded referral agency exemptions to include consulting, youth sports coaching, caddying. I've not had any caddies call me. Wedding planning services provided by wedding and vendors, interpreters, etc. Excludes high hazard industry services, janitorial, delivery, courier, transportation, trucking, etc. It revises the definition of service provider to include youth sports coaches and revises the definition of tutor. Amends the professional services exemption. If there's any publishers or writers here, it eliminates the 35 per year submission limit to a single publisher for freelance writers. Most importantly, on the bottom, it adds a number of workers on miscellaneous lists. Okay, so and there are several exemptions that were added, and I have found that even a lot of attorneys in my own office here are misunderstanding some of these things because they're running around saying, well, there's been a lot of exemptions added and exceptions added to AB 5. So maybe some things fall under those exemptions. So you should be if you think you have an exception to AB 5, be very careful. Talk to an experienced employment attorney and see if your exception applies. Even if it does apply, you still have to fall under the old Borello or control test. And what is that? It means that if you control, as an employer, as a business, if you control that worker, then you're probably going to fall under the definition of an employee, not an independent contractor. So be very careful with AB 5. Be very careful with the independent contractor versus employee test. Okay, it's still a very big minefield, probably bigger than ever for employers. Prop 22, app-based drivers. If we have any app-based drivers or folks in the room who hire app-based drivers, there's a limited exception now. This provides that an app-based driver is an independent contractor and not an employee or agent. With respect to that app-based driver's relationship with a network company, if all of the following conditions are met. The network company does not unilaterally prescribe specific dates, times of day, or minimum number of hours during which the app-based driver must be logged into the company's online enabled application or platform. B, the network company does not require the app-based driver to accept any specific rideshare service or delivery service request as a condition of maintaining access to the online platform. The network company does not restrict the app-based driver from performing rideshare services or delivery services. And D, the network company does not restrict the app-based driver from working in any other lawful occupation or business. So, yeah, obviously we're talking like, you know, DoorDash, all these delivery things, delivery drivers, these sorts of things. So there's an exception for these folks, but they've got to meet all these requirements. And so again, I would encourage you, if you're one of those drivers or if you're one of those companies that employ these folks, I shouldn't say employ these folks, that hire these folks, pay these folks, talk to experienced counsel, make sure you meet these requirements. Don't just jump into it saying, yeah, my people are going to be independent contractors. It's still a big minefield. This is a big one. The next one. Newspaper carriers remain independent contractors for one more year, AB 323. I say that sarcastically. Does anybody still take a newspaper? I don't know. But if they do, newspaper carriers are still exempt under AB 5 for 1 more year. I honestly don't remember the last time I read an actual newspaper. I read them online. I'm sure most people do. But if there are any still newspaper carriers out there, they remain independent contractors for at least 1 more year under AB 323. This actually is a big one. Annual paid data reports. I remember when we started talking about this, some employers were a bit trepidatious about this one. On top of the second bullet point, beginning March 31, 2021, so coming up in just over a month, and annually thereafter, by the same deadline, private employers with 100 or more employees that are required to submit an annual EEO-1 report, and if you have more than 100 employees, you know what that is, will also now be required to submit a paid data report for the prior calendar year to the DFEH. So not the DLSE, but the DFEH, which can also then share this report with the DLSE. The paid data report must include very specific information, including the number of employees by race, ethnicity, and sex in the following categories you can see there. Last bullet point, employers also need to identify the number of employees by race, ethnicity, and sex whose annual earnings fall within each of the pay bands used by the United States Bureau of Labor Statistics. For this particular purpose, the employer will use the employee's earnings as shown on IRS Form W-2. So why do they want that information? I don't know, but it can't be for any good purpose that I can think of. Moving on. Expand authorization for Labor Commission to provide representation to employees. Some of you may know, if you've ever gone through a hearing process and beyond with the Labor Commissioner, if an employee goes to the Labor Commissioner, has a hearing, which is their word for a trial, and then there's an appeal filed, the Labor Commissioner has always had the right to provide an attorney to that employee in court, Superior Court. SB 1384 now provides that the Labor Commissioner can also appoint an attorney to represent an employee if the claim is subject to arbitration as opposed to being tried in the Superior Court. Accordingly, SB 1384 also requires that a petition to compel arbitration of a claim that is pending must also be served on the Labor Commissioner. So don't forget to do that. If there's an appeal to a Labor Commissioner award, either the employee or employer, and there's a petition to compel arbitration, please make sure that is served upon the Labor Commissioner so they can decide whether they want to appoint an attorney for the employee. Okay. Okay, overtime. We've been talking about this for several years now, the phased-in overtime for agricultural field workers. This was enacted, excuse me, 5 years ago now in 2016. It introduced overtime compensation rules consistent with other wage orders to Wage Order 14, which is the agricultural wage order. This phase-in began in 2019 for employers with 26 or more employees. This next slide, as you can see, Dan has highlighted what is in effect for 2021. So if you are an agricultural employer, and I want to make this key distinction because every year that I talk about this, I have employers that are surprised that even though they're in the ag industry, these ag overtime rules do not apply to their secretarial workers or their mechanical workers. This only applies these 60, what was traditionally 60 hours in a week overtime back prior to 2019. It only applies to those folks that are considered agricultural field workers. Okay, so please be aware of that. But for your agricultural field workers, as of January 1, 2021, overtime now kicks in 8.5 hours per day or 45 hours per week. Okay, so please make sure that you update your overtime rules and policies to 8.5 hours per day and 45 hours per week, and be aware that's going to change again next year. Okay. All right. Traditional minimum wage increases. This was enacted, which is 6 years ago now, 2015. Incremental increases through January 1, 2023. Beginning August 1, 2022, so midway through next year, the minimum wage will be adjusted annually by the California Director of Finance. So we'll all be excited to see what that is. Increases will be implemented the following January 1. It's only increases, no decreases. Okay, so our minimum wage increase schedule, as Dan has highlighted here, as of January 1, 2021, 26 or more employees is now $14 per hour. 25 or fewer employees is $13 per hour. So make sure that you are following those minimum wage amounts as of January 1. Of course, that also kicks in the new minimum salaries for exempt workers. Okay, we have the formula right up there. It is minimum salary that must be paid to an employee classified as exempt. Okay, under the 3 exemptions, executive, administrative, and professional, is 2 times the minimum wage for full-time work. All right, so that's $14 an hour times 2 times 2080 full-time work is $58,240, and that's for 26 or more employees. For 25 or less employees, the exempt salary would be $54,080. Okay, hopefully everyone understands that. I believe that's the. Oh no, we have tip sharing. Let's go on. Okay, so real quickly, the last thing I want to cover here before I turn it over to Dan. Last 2 things I want to cover is FLSA tip sharing. If you're in an industry that has tips, your employees have tips. December 22, 2020, the Department of Labor announced a final rule revising regulations regarding tip sharing, consistent with the statute. Here's what you need to know. Managers or supervisors are prohibited from keeping any portion of employees' tips, regardless of whether the employer takes a tip credit. If an employer does take a tip credit on their taxes, the tip pool cannot include non-traditional tip sharing employees such as cooks and dishwashers. If the employer does not take a tip credit, non-traditional employees can be included in the tip pool. So there's some changes to the FLSA tip sharing. Last thing I want to cover, moving on to the next slide. Some other miscellaneous changes to wage and hour rules effective January 1. IRS mileage rate for 2021 decreased to 56 cents per mile. So make sure you make that change. Some exemptions, some catch-all exemptions here. The physician's exemption, the minimum hourly rate is now $86.49. And the computer professional exemption, the minimum hourly rate is now $47.48. And you can see the minimum monthly salary, annual salary, which goes along with that hourly rate. Okay. Do we have any questions, Hillary?
Not yet.
No. Okay, then I'm gonna turn it over to Dan.
Job.
Well, maybe everybody was just blown away by that and doesn't understand anything. I'm gonna turn it over to Dan to cover safety.
All right, very good. Thank you, Jerry, and good morning, everyone. Welcome to our annual update. Just going through wage and hour probably is enough for all of you to want to take a walk around the block and clear your head, but we don't have time for that. We're going to move on to some other topics and hopefully continue to educate you on these many changes coming out of Sacramento and DC this year. I'll comment to Jerry that I haven't heard from any caddies either, so maybe there's a marketing opportunity for us there because at least my phone has not been ringing off the hook from caddies. So we'll continue to look into that. So let's talk about safety then and some of these changes that kind of fall into this category. So first is AB 2537. This is a specific statute directed at direct care workers. And so those who fall under that definition, AB 2537 says that employers of those individuals are now required to stockpile new, unused, and unexpired PPE equal to 3 months worth of normal consumption. There's 7 types of PPE that have to be stockpiled and maintained that you can see there. And you're probably already doing that if you're in that industry. And so you want to continue doing that, and just be aware that Cal OSHA could come in and ask for records of your inventory and written procedures to make sure that you are compliant with that particular code section. And there's penalties, of course, if you're not. So, but again, this is specific to direct care workers. and not applicable across the board to all employers. AB 685 is a big statute in terms of its application. It is effective January 1, 2021. And it's important because it creates obligations for employers to track and report COVID-19 cases. And so AB 685 has two different notice requirements component to it. And what you're seeing on the first slide here is notice requirements based on a potential exposure as they talk about it in the statute. So within one business day of a potential exposure based on a positive COVID-19 case, the employer has to provide written notice to all employees and employers of subcontractors who are on the premises at the same work site as the qualifying individual within the infectious period that they may have been exposed to COVID-19. So there's a lot of pieces to that particular bullet point. We're talking first of all about the written notice, but only to workers who were on the premises at the same work site as what they define a qualified individual within the infectious period. So it's limited in the sense that we're only having to give notice to those who were on the premises at the same work site. And the defined work site under the statute in a pretty broad sense, in that they recognize that any particular work site, let's say that you are a distribution company and you have multiple warehouse locations on your property, plus a separate building where the office employees work. Although arguably that's all part of your campus, where you're doing work, each of those different buildings could be considered a separate work site as defined under the statute. So you would look at this obligation in terms of providing notice based on where the potential exposure occurred, and you would then be limited to only providing notice to that group of employees that were on the work site and had the contact, so to speak, with the qualifying individual. You also have to provide notice to employee representatives and unions. The notice has to include information about employee benefits, workers' compensation, leave of absence opportunities, sick leave, things like that must be incorporated in the notice. So these are all parts of this first aspect of the notice obligations under 685. So in terms of looking at that and how we sort of ultimately deduce whether or not we have to provide the notice, the statute talks about what a notice of potential exposure means. And it says that, notification to the employer or representative from a public health official or a doctor, basically, that an employee was exposed to a qualified individual at the work site, or we get notification from the employee themselves that they're a qualified individual, or we get notification through some type of testing protocol that the employer has that the employee is basically positive for COVID-19. So we look through each of these various definitions to determine, do we have information, have we received information from one of these sources that one of our employees may have COVID-19, they may be a qualified individual, as you see defined there at the bottom of this slide, where they have a positive test, or they've been told to isolate. So if we get information about one of our employees, if they meet that definition, then we have to go back to our work site then and evaluate which of our employees might have had contact with this person, to whom then we have to give this notice within one business day. So keep in mind that this is a notice statute. It's not the same type of statute or regulation as we will be talking about later today, where we're talking about who needs to be excluded from the workplace. When do we need to send employees home, for example, because they've had contact with someone who has COVID-19, or maybe they were exposed at home and then they came to work, and so we may be deciding whether or not we need to exclude that employee from the workplace. That's a different issue than what we're talking about here. This is just a notice obligation, where if we decide someone has had that potential exposure to someone who's a qualified individual, then we have to send this letter out to our employees, letting them know that they may have had exposure to that particular person. It'll be a separate issue as to whether or not they've had close contact with them, such that we'd actually might need to send them home. This is really just focusing on a notice obligation. So that's one piece of AB 685. And the statute does, define exactly what an infectious period is as well, as we're evaluating who might have had contact with this qualifying individual during the infectious period. The second part of AB 685 has to do with notice requirements that go broader than just notice to a particular individual employee. Under this part of AB 685, if an employer experiences what the law defines as a COVID-19 outbreak, then we have to notify the local public health agency within 48 hours of the names, number, occupation, and work site of the employees who are qualifying individuals, the business address, and the NAICS code of the work site. That's the type of industry or business that you're involved. And they define an outbreak under the California Department of Public Health definition as an outbreak in a non-healthcare workplace where you have at least 3 COVID-19 cases among workers at the same work site within a 14-day period. So if you learn of 3 cases of COVID-19 within your workers within a 14-day period, that's considered an outbreak, and you need to notify the California Department of Public Health of the fact that that occurred. So if you had 2 during the 14-day period and the next one didn't happen until 2 weeks later, you wouldn't meet that definition of an outbreak and would not have an obligation to report that to public health. But if you do have 3 instances within that 14-day period, then you have to report. And these aren't necessarily situations where you're confident that the exposure happened at work. It could be that you had 3 exposures that you're confident happened outside of work, but you may still meet that definition of 3 cases within the 14-day period and have to notify public health. Again, this is just a notification obligation. It's a separate issue as to what you do with that information vis-a-vis the particular individual employees and whether you need to send them home, exclude them from the workplace, things like that. This is a focus on a reporting obligation, with the idea being that if public health can identify some particular problems in a workplace where you have a large number of cases happening within a short amount of time, then they may need to investigate to determine whether or not you're being aggressive enough as an employer to prevent COVID-19 in your workplace. For healthcare facilities, it's a different obligation. Healthcare facilities need to follow the CDPH reporting guidance for healthcare facilities. That's a whole different set of rules. These really are just applying to the non-healthcare employers. All right, so that's the 2 notice requirements associated with AB 685. 685, though, also brought some additional powers to Cal OSHA. This will be in effect until January 1, 2023. And it amends the labor code to permit Cal OSHA to close workplaces when, in the opinion of the division, the place of employment exposes workers to the risk of infection to COVID-19 so as to constitute an imminent hazard to employees. So if Cal OSHA, in its opinion, deems that things are occurring in your workplace that are creating an imminent hazard to your employees related to COVID-19, they can shut you down, basically. And so Cal OSHA has always had some authority to shut businesses down, but this is really an enhanced power that they get through AB 685. It is somewhat limited, though, in that if we use the hypothetical I gave a few minutes ago of a workplace with multiple buildings, for example, a distribution center with multiple warehouses plus a different building for the office, then those would be, in essence, kind of independent and separate workplaces. So they would have to identify where the supposed imminent hazard exists. And then if they're going to shut down that particular part of the business, they would be limited to really only that area. They can't necessarily just shut down your entire business because they find an imminent hazard in one part of it. So that's at least gives some protection to employers as well. And then Cal OSHA will post a notice in a conspicuous place at your place of business if they determine that that imminent hazard exists. Another aspect of AB 685 is that if Cal OSHA, through finding this imminent hazard, concludes that a citation should issue, in particular a serious citation, then they can issue that citation, but they can forego one of the steps that normally precedes a serious citation, which is giving the employer what's called a 1BY or 1BY notice. That notice is one, if you've ever had, been cited by Cal OSHA for a serious citation, gives the employer advance notice that the division is considering issuing a serious citation, and gives the employer an opportunity to inform Cal OSHA about why they think that serious citation should not issue. Well, AB 685 allows Cal OSHA to skip that step, which means that Cal OSHA can move to a hearing and move to addressing that serious citation in a more expedited fashion than they would with other serious citation situations. So that's AB 65. You want to continue to monitor that. And if you have any of these exposures in the workplace, consider and follow your reporting obligations. All right, then AB 2043. This was urgency legislation that was passed September 28, 2020. Basically, it obligated Cal OSHA to disseminate information in English and Spanish to employers in ag, essentially, giving them information from their guidance documents. But this is really something that Cal OSHA was obligated to do, not so much you as an employer. All right, another important change in the law that happened on November 30, so just a few weeks ago, were these emergency temporary standards that were issued by Cal OSHA. And as you'll see as we continue to go through this presentation today, this is somewhat of an unusual year, where in that usually Jerry and I are talking about changes that occurred through the course of the preceding calendar year, with an emphasis on pieces of legislation that the governor signed, typically in the September timeframe, most of them going into effect the first of the year that follows him signing those pieces of legislation. But this year, we're seeing and did see a lot of activity just in the last 60 days. So it's a little unusual in that these obligations are being sprung on employers at the end of the year, and creating some rather onerous obligations on them to comply in a very short time frame. So this particular set of emergency temporary standards that Cal OSHA passed, did go into effect on November 30th. It applies to all California employers and employees except employment places with one employee who does not have contact with other people. So find that a little bit amusing. I suppose such a place of employment exists, but I don't think it would be very common. It does not apply to employees working at home or to employees covered by other Cal OSHA standards governing the aerosol transmissible diseases regulations. An important part of this emergency standards, though, is that Cal OSHA created an obligation on employers to implement a COVID-19 prevention program or prevention plan. And so this is something that technically all of you are supposed to have in effect now, with only getting notice, as of essentially December 1st, you're supposed to already have this COVID-19 prevention plan in place. To help you with that process, Cal OSHA did create a model COVID-19 prevention program that is available on their website. It's a pretty robust model. It does really help employers and guide them through the creation of their plan, but it is something that employers should be looking at to make sure they're either adding to or amending their injury and illness prevention program, their IIPP. If you're not familiar with IIPP, that's something else that you're obligated to have in place in your workplace. But this COVID-19 prevention program should supplement that IIPP program, but focus on the things you're doing to prevent the spread of COVID-19 in your workplace. With respect to that effective written program that Cal OSHA is now requiring, you have to include an identification and evaluation of employee exposures to COVID-19 and the health hazards. You have to implement effective policies and procedures to correct unsafe and unhealthy conditions, such as imposing physical distancing requirements, modifying your workplace. A lot of places of business have put up plexiglass shields and taking temperatures of their employees, monitoring employees' health, staggering schedules, things that you probably have already implemented, you need to incorporate in your written COVID-19 prevention program and document that you are doing all of those things. You want to make sure you're providing and ensures workers are wearing face coverings when appropriate. The temporary standards also mandate, as part of your written COVID-19 infection prevention program, that you implement training as well on how the virus is spread, prevention techniques, employee benefits that might be available if an employee has to go off work because they had close contact with someone that has COVID-19 or in fact has COVID-19 themselves. So check out the resources that are on Cal OSHA's website. Even though they sort of sprung this on employers without much notice, they did also try and provide a lot of guidance on their website, including that template that I mentioned earlier. So these are all parts of the temporary standards. The temporary standards also talked about situations where you need to exclude employees from the workplace in the event that they have a COVID-19 test. So we already were doing a lot of this because of guidance that we received from CDC and the Public Health Department, where we were routinely excluding employees who either came in close contact with someone with COVID-19, close contact historically, well, a short history here in 2020, but being defined as someone who was within 6 feet of someone for 15 minutes or more during a 24-hour period who has COVID-19. So that close contact or someone who actually has a positive test, during the past year would have caused us to have that person isolate at home anyway. But these emergency temporary standards define specifically that exclusion applies to each COVID-19 case, which is a person who has a COVID-19 test, is subject to a COVID-19 related order to isolate issued by local or state health officials, or has died due to COVID-19. A COVID-19 case with symptoms must be excluded from the workplace until at least 24 hours have passed since a fever of 100.4 or higher has resolved without medication, the symptoms have improved, and at least 10 days have passed since the symptoms first appeared. And then if no symptoms, exclude for at least 10 days since the date that the test was positive. So these are all guidelines, standards that are being issued by Cal OSHA. When an important piece of these temporary standards is language that directs employers in California to compensate employees when they are excluded from the workplace. So we're going to be talking in a little while, in a few minutes at least, beginning with a slide or two from now, about some of the things that you all have already dealt with this year, including that Families First Coronavirus Response Act, and when you needed to provide the 80 hours of sick leave or additional time off under the FMLA piece of that, how much you had to pay them, all those kinds of things. And Jerry's going to discuss those in just a few minutes. But a lot of that has now expired, and Cal OSHA is coming in behind that, indicating with these temporary standards that employers have an obligation to compensate employees who are excluded from the workplace under these conditions, that the employer must continue and maintain employees' earnings, seniority, and all other employee rights and benefits. They have to reinstate the employee to their former job and allow the employee to use employer-provided sick leave benefits. Considering and taking into account whether or not you have paid the employee in accordance with these emergency temporary standards, Cal OSHA says that you can consider as an employer the payments the employee receives from public sources. So if you have an obligation to continue their compensation, but they're receiving SDI benefits or unemployment insurance benefits, then you can take that into account in terms of your obligation to maintain their earnings, and presumably then just supplement their compensation with monies above what they're receiving from the public sources. But there's a couple of very important exceptions to this rule regarding your obligation to pay employees who have been excluded from the workplace because of their COVID-19 exposure or positive test. One is that it does not apply to any period of time during which the employee is unable to work for reasons other than protecting persons at the workplace from possible COVID-19 transmissions. I had a situation arise just last week where an employee reported to the employer that they tested positive for COVID-19. It appeared to not be work-related, but still they did have a positive COVID-19 test. But that employee had already been off of work because they had had an injury to their ankle. And so they were essentially about to be put on CFRA leave anyway. And so I think there an employer could argue that I don't need to pay that employee under this temporary standard because they're off of work for reasons that have nothing to do with COVID-19, i.e. the ankle. Another and perhaps even more important exception is the second one there, which says that this obligation to pay employees who are excluded from the workplace does not apply where the employer demonstrates that the COVID-19 exposure is not work-related. So that's very important. In my experience, just dealing with these issues with clients for the last, incredibly, almost a year now, most of the COVID-19 positives that are reported to the employer are fairly clearly not work-related. Of course, not all of them are, and sometimes it's gray, but the majority of them arise because an employee contracts COVID-19 from people they're living with or a family gathering, and it's fairly clear that it's not work-related. Well, if you can demonstrate that and are fairly confident that it's not work-related, then this obligation to pay employees under this emergency temporary standards would presumably not exist. All right, so that's our safety section. I'm going to turn it back over to Jerry to talk about leaves of absence.
Thank you, Dan. I do notice we have one question here in the queue that looks like it relates back to when I was talking about reimbursement under Labor Code Section 2802. So I'll go ahead and take it quickly now. From Elena LaRoque, hope I'm saying that right. And Ms. LaRoque asks, cell phone reimbursement, what is the amount? And that's a good question, Ms. LaRoque. Reasonable, pay a reasonable amount. What's reasonable? So Dan can jump in here if he knows something different or has a different thought. But so if you have an employee that has to use their personal cell phone for business, for on-the-job use, you do have to reimburse that employee for an adequate amount to cover their to cover their business use. The problem is, most times, in most instances now, including myself, I mean, you pay a flat amount for your cell phone use. So I'm the last I know, I believe the accepted standard for cell phone reimbursement to employees is $25 a month. I'm not aware of that. I'm also not aware of any labor commissioner decision that says it's $25 a month. That's just kind of an industry accepted standard. So I tell my clients that $25 a month. However, with the caveat that you tell the employee in writing, we're reimbursing you $25 a month for reasonable use of your cell phone. However, if you feel that the $25 a month does not adequately reimburse you for business use, please submit your cell phone bill and we'll look at it and inspect it. And if it appears that we owe you more than $25 per month, we'll reimburse you, accordingly. So hopefully that answers the question. There's not a black and white answer to that, but that's about the best we can do. Okay. All right, so leaves of absences. The first leave of absence we need to talk about today is a big one. The California Family Rights Act, which has been around for years, but it's been expanded and it's been amended. So effective January 1, 2021, the the California Family Rights Act now applies to all employers with 5 or more employees. And that, that's a huge change, because it has always been until January 1, it has always been 50 or more employees. So, generally, I mean, as long as my career has been in employment law, we've been able to say to employers, the California Family Rights Act, CFRA, as we call it, really tracks FMLA, right? With rare exception, it's the same eligibility requirements, it's the same leave purposes. So we really, with rare exception, we didn't really have to make much of a distinction between the two, okay? There were sometimes you did, but by and large, it applied to the same employers and for the same stuff. Well, now we got a big sea change here, because the Family Medical Leave Act, FMLA, still applies to employers with 50 or more employees, but now CFRA has changed. So if you're I wish I was in front of you right now so I could ask this question and see the hands raised. How many of you have between 5 and 49 employees, to know how big of the audience is that I'm talking to that this now applies to, because it's a whole new world for those employers with 49 or fewer employees, because now you have to get used to everything under the Family Rights Act. And we're going to talk about a few of those things. Even for those employers with 50 or more, okay, that FMLA has traditionally applied to, I mean, there are some significant differences that you're going to have to deal with. And we'll talk about some of those. But the California Family Rights Act allows eligible employees to take up to 12 weeks, work weeks of unpaid job protected family medical leave for specified reasons within any 12-month period. To be eligible, an employee must, 1, have been employed for at least 12 months, and 2, have worked at least 1,250 hours in the 12-month period preceding the leave. You'll notice, if you're familiar with FMLA, that SB 1383 eliminates the previous 75-mile radius requirement. Okay, so it's just those 2 requirements now. Next slide. It also expands the list of individuals for whom leave may be taken to provide care. So this is something that even I'll call them my FMLA clients, okay, now have to be aware of, because a list of eligibility requirements or purposes is now expanded. The list now includes a grandparent, a grandchild, and sibling. It already includes child, parent, spouse, domestic partner. Oddly enough, it adds a definition for parent-in-law, but does not include them on the list. So who cares? I don't know. It expands the definition of child to eliminate the requirement that the child be either under 18 or an adult dependent. So again, that's a change that even my FMLA clients need to be aware of. It adopts the FMLA provisions for allowing time off for qualifying exigencies related to the covered active duty or call to covered active duty of an employee's spouse, domestic partner, child, or parent in the United States Armed Forces. Next slide. This is important. It removes a current CFRA provision that provides if both parents are employed by the same employer and are otherwise entitled to leave, the employer would not be required to grant leave that is greater than 12 weeks for the birth, adoption, or foster care of the child. So in other words, if you had 2 parents of a child that then both parents worked for you, previously you would have been allowed to limit the total leave that both parents could take to a total of 12 weeks. Okay, total of 12. 10 and 2, 6 and 6, 11 and 1. I don't care how you split it up, parents, but you're only taking 12 total. Well, that's gone now. Each could take 12. Also, it eliminates the key employee exception to an employee's right of reinstatement. Previously, you could notify an employee at the time that they take the leave, if you put in their notice letter, that if they're considered a key employee, and there's some definitions of key employee, that you reserve the right to not reinstate them upon their return or eligibility to return. That's eliminated now. Also, importantly, this supersedes the New Parent Leave Act. So you might recall that, I don't even remember when it was it 2 years ago now, that the New Parent Leave Act came into place? That was a leave law that said if you had 20 or more employees in California, this was a baby bonding leave act called the New Parent Leave Act. Well, now there's no reason to have the New Parent Leave Act because SIFRA now applies to any employer with 5 or more employees, and it includes baby bonding. So if you have the New Parent Leave Act in your handbook, you can just take that right out, but make sure you replace it with an updated SIFRA leave policy. Okay, for those who are newly covered by SIFRA, yeah, here's some things you need to know. Okay, if you've never been covered by SIFRA or Fmla before because you're under 50 employees, here's some things you need to know and become familiar with. This covers serious health conditions of an employee, including pregnancy disability. Pregnancy disability is excluded, of course, because that's a separate leave act under SIFRA. To care for a family member with a serious health condition. Leave for reason of the birth of a child of the employee or the placement of a child with an employee in connection with the adoption or foster care. Qualifying exigency related to covered active duty or call to covered active duty of an employee's spouse, domestic partner, child, or a parent in the armed forces of the U.S. Next slide. For those who are new to SIFRA, you will also need to become familiar with eligibility requirements, definitions, such as serious health. What's a serious health condition? Sending notice of SIFRA leave to the employee. Reinstatement of the employees upon expiration of the leave, exhaustion of the leave. Overlap of paid family leave. ADA FEHA impact. That's a big one. Overlap with workers' compensation. And you got to create a policy in your employee handbook. Okay. And as I mentioned a few seconds ago, if you already have an FMLA policy because you're over 50, you have to need the update. You need to update that policy because of the differences between SIFRA and FMLA. Okay. For those who are already covered by FMLA, here are some of the key differences you need to know and differentiate between the two leaves. Pregnancy disability is considered a serious health condition under FMLA, but not under SIFRA. So the key distinction there is an employee could stack their leaves. Okay, so they could take they could take a leave under SIFRA for pregnancy disability, okay, separate and apart from FMLA, and then take their baby bonding under FMLA. Okay, so they could get 24 weeks of leave. If the leave is to care for a serious health condition of a registered domestic partner, adult child, grandparent, or sibling, 12 weeks of SIFRA leave may not be provided, or may be provided that does not run concurrent with FMLA. So these are some reasons that a person could take 12 weeks of leave under SIFRA, but not exhaust their leave under FMLA and still have 12 weeks of leave under FMLA available to them. If the leave is to care for an employee's parent, child, spouse, or next of kin, who is a covered service member with a serious injury or illness for 26 weeks under FMLA, the SIFRA leave may run concurrently for 12 of those weeks, but not the other 14. Okay, so there's some key distinctions here. Okay, so that's really quick thumbnail sketch of FMLA, differences now between FMLA and SIFRA. So let's spend a few minutes talking about the Families First Coronavirus Response Act. As most of you probably know, it was enacted last year by Congress in March or April. It expired on December 31, 2020. It applied to those employers with 500 or fewer employees. It was determined as of the time your employee's leave was to be taken. It included full-time and part-time employees. It included both an emergency paid sick leave component and an emergency paid family leave component to be eligible. I'm not going to spend a whole lot of time on this because it's expired, but an employee, no matter how long employed, qualified if the employer was subject to state, local, or federal quarantine or isolation order related to COVID, had been advised by a healthcare provider to self-quarantine, was experiencing COVID-19 symptoms and was seeking medical diagnosis, was caring for an individual subject to an order described in 1 or 2 above, was caring for a child whose school or place of care is closed or child care provider is unavailable for reasons related to COVID, or was experiencing any other substantially similar condition specified by the Secretary of Health and Human Services. But what about extension of the FFCRA into 2021? Okay, I find that there has been some confusion about this with my clients and other folks calling me. Excuse me. If you're a covered employer, as we described it in the last slide, you may voluntarily extend emergency paid sick leave or emergency family medical leave into 2021. However, if you do, you need to do it carefully. Okay, and I'm not telling you not to do it, but I'm telling you if you do it, you need to think about it carefully and apply it carefully. It does extend the tax credit for private and nonprofit employers, not government employers, with less than 500 employees through March 31, 2021. If you're a government employer, possibly you can extend the leave, but with options, but would not get the tax credit. Employers would appear to be able to extend both leaves or elect to extend only one of the leaves, okay, the medical leave or the paid sick leave. An employer that extends both the FFCRA leaves must comply with the requirements of the EPSL and the EF paid sick leave and the family medical leave. You have to comply with all the requirements. The FFCRA had provided that unused sick leave would not carry over to 2021. Now the unused sick leave can be used in the first quarter through March 31st if the employer elects to allow the sick leave in 2021. Okay? But if you choose to do it, you have to comply with all the requirements that were in place. Next slide. If you have an employee who already used their allotment of sick leave, they do not get any more. Okay, they don't get a new allotment in 2021. Here's a key. Here's a big one. Employers should be consistent among employees if electing to extend the paid sick leave and family medical leave. So like anything else, like any of the leave, don't be discriminatory in your application of it. Make sure you apply it uniformly as a blanket leave to all eligible employees. Okay, stay tuned for clarifying. So again, if I was here, I'd ask you to raise your hands and tell me how many of you as employers have decided to extend it. And if you're going to decide to extend it, you should decide now or previously to extend it. I wouldn't wait till somebody comes to you and asks for leave and then huddle up and say, are we going to extend it? What do you think? I mean, you should make a corporate decision already if you're going to extend this to your employees or not. Some frequently asked questions about extension of leave. I was eligible for leave under FFCRA in 2020, but I did not use any of the leave. Am I still entitled to take paid sick leave or expanded family medical leave after December 31? Yes, if your employer has decided to extend it after December 31. But if your employer has not voluntarily decided to extend it, no, you cannot take it. Question 105. I used 6 weeks of FFCRA leave between April 1, 2020 and December 31, 2020, because for a qualifying reason. Okay. My employer allowed me to take time off, but did not pay me for my last 2 weeks of FFCRA leave. Is my employer required to pay me for my last 2 weeks of leave if the FFCRA has expired? Yes. Even though FFCRA expired in December 31, if you as an employer did not pay all of it to the employee in 2020, I don't know why you wouldn't have done that. But if you didn't, yes, you're still required to pay them. The statute of limitations has not run on paying that employee for that leave as of December 31. Okay. Next slide. Okay, so this is AB 1867. This is the California equivalent, okay, to the supplemental COVID sick leave. This was effective for any employers with more than 500 employees. This was the emergency legislation effective between September 9, 2020 through December 31, 2020, or until expiration of FFCRA if extended, which it wasn't except voluntarily. Again, it applies to employers with more than 500 employees. Employers must provide up to 80 hours of paid time off to employees who are unable to work because they are subject to a federal, state, or local quarantine or isolation order. Advised by a healthcare provider to self-quarantine or self-isolate due to COVID-19 related reasons, or prohibited from working by the employer due to health concerns related to the potential transmission of COVID-19. The employer must provide a notice to the employees. They must include all available paid sick leave on pay stubs. Generally, AB 1867 treated these paid sick leave days as subject to Labor Code Section 248 mandatory paid sick leave law. Okay. It essentially codified Executive Order in 5120, which provided paid sick leave for food sector workers, effective September 9, 2020, and retroactive to April 16, 2020, date of the executive order. No additional leave must be provided if the employer already provided leave under the executive order. So this is part 2 of the executive order, and it only applied to paid sick leave for food sector workers. This defines what the food facility was. Yeah, Dan wants me to move on. Okay, I will. We must be short on time. This is an important part of AB 1867. It's the third part. It talks about mediation for small employers, which is considered 5 employees or less. Subject to California Family Rights Act and mediation. It creates a small employer family leave mediation pilot program for employers between 5 and 19 employees. If your employee files a claim with the DFEH under this law, within 30 days of their receipt of a right to sue notice alleging a violation of CFRA, either the employee or the employer may request that the parties participate in mediation. Okay, the employee cannot pursue litigation until the mediation is complete. The DFEH shall initiate the mediation, blah, 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 blah. Okay, so there's a new mediation requirement or option there. Next slide. Expansion of protected time off for victims of crime leaves. As you know, that you're not allowed to discriminate against victims of crime in California. AB 2992 expands the definition of what a crime is for these leaves of absences and your inability to discriminate. Now, this includes a victim of a crime that caused either physical injury or that caused mental injury and included a threat of physical injury. And 3, a person whose immediate family member is deceased as a direct result of a crime. Or 4, for purposes of appearing in court in response to a subpoena or court order, any person against whom any crime has been committed. So essentially, there's a big expansion of what's a crime under there. Next slide. Okay, I'm not going to spend any time at all on this other than to tell you, paid family leave, again, it's not a leave of absence for employers, it's a benefit to employees. But know that there's been a change to what's the qualifying exigency under paid family leave. If you have any questions about this, call your employment attorney and they can walk you through when you have to provide notice of eligibility for paid family leave to an employee. Okay. Kin care amendments effective January 1, 2021. AB 2017 amended the labor code to specify that designation of sick leave for kin care purposes shall be made at the sole discretion of the employee. The employer cannot charge a sick day against kin care unless the employee so designates at the time to be used in that manner. Okay. Hand washing breaks for food facility employees, SB 729. This amends the Health and Safety Code to authorize food employees to wash his or her hands every 30 minutes and even more if needed. Let's hope they wash them more often than every 30 minutes. It provides up to 80 hours of paid sick leave for food sector employees, which we already talked about in the other executive order. And it requires posting of a notice regarding paid sick leave benefits for those employees. And it expands the definitions of employer and employee. Next slide. And we're going to turn it over to Dan for the next section.
All right, very good. Thanks, Jerry. So we're going to talk about sort of a potpourri of different topics here. We've lumped under FEHA and notice and such. but all of them having to do primarily with discrimination-related issues. And so first is AB 979. And what we see with AB 979 is an expansion of a law that was passed a couple of years ago that mandated that certain companies, those who are publicly held domestic or foreign corporations who have a principal executive office in California, that the previous law had indicated that the board of directors had to include more gender diversity. And AB 979 expands that to say that in addition to gender diversity, we want to make sure that those publicly held corporations also have boards that include members, board of directors members from what they've defined as the underrepresented community that you see defined there as those who are Black, African American, Hispanic, Latino, Asian, Pacific Islander, Native American, Native Hawaiian, or Alaska Native, or gay, lesbian, bisexual, or transgender. So it's a push by the California legislature to just add more diversity to those publicly held domestic and foreign corporations, which is probably not very many of you that are part of this presentation, but just take notice that this is a trend we're seeing in California. AB 1963 is an important change, but applicable to a rather small group of individuals, in that it is a statute that has turned human resources professionals and certain supervisors into mandated reporters of suspected child abuse. But it only applies to those businesses that employ minors, which is not very many businesses. But for those of you who do employ minors, just understand that if you're in human resources and you're the person who is designated by the employer to accept complaints of misconduct under the Fair Employment and Housing Act, and you have 5 or more employees, that if you receive information about suspected child abuse, that you now have an obligation as a mandated reporter to inform law enforcement authorities about that physical abuse, sexual abuse, exploitation, willful cruelty, etc. So again, applicable to a small group of employers, but very important that you take that responsibility seriously if you're either a supervisor or an HR manager within that organization. All right, so this change here is reflecting that the Fair Employment and Housing Council is considering modifying California law with respect to how companies reasonably accommodate those who are associated with individuals who have a disability. So in California, the law protects not only individuals with a physical or mental disability as defined under the law, but also individuals who are associated with persons with disabilities. And the Fair Employment and Housing Council is taking input from employers for just a few more days now through February 1st, seeking responses to the 7 questions that you have listed on this slide and this following slide. I'm not going to go through each of those questions specifically. If you have a strong opinion about those things and want to get your opinion heard by the Fair Employment and Housing Council, then get that off to them in the next few days. Near the end of the year, the EEOC published some new guidance regarding vaccinations and COVID-19. This guidance was one that we had been waiting for because we had seen through the course of the year the Equal Employment Opportunity Commission providing guidance on how employers should deal with individuals who had COVID-19, what questions they should ask, when could they send them out to be tested, what kind of again, information could be requested of those individuals, but we hadn't seen them address the issue of vaccinations because that was a new and up and coming issue as the vaccines were beginning to get rolled out. Well, near the end of the year, the EEOC did provide us some guidance through their technical assistance and questions and answers format. And through that process, they essentially answered a question that a lot of employers had, which is, can an employer mandate that their employees get vaccinated, or can it only be done on a voluntary basis? And so indirectly, basically, the EEOC answered that question through their Q&A process. So initially, they talked about what is a medical examination, and is the process of getting an employee vaccinated, even a medical examination that would be subject to the protections under physical and mental disability law. And they answered that question essentially in the negative, that a vaccination itself is not a medical examination. But they noted that even though the vaccination itself is not a medical examination, by virtue of giving that vaccination, the healthcare providers or potentially the employer would normally be asking the individual a lot of questions, get a health history, for example. They'd be asking questions about that person's health background. And that process of getting that information, could be considered part of a medical examination, or at minimum would be obtaining information that's going to be protected by the ADA's provisions on disability-related inquiries. So they're identifying this as sort of a run-up to their answer as to whether or not an employer can mandate that employees receive the vaccine. And then in the next question, they implicitly tell us that an employer can mandate that employees get the vaccine, because they're answering the question, if the employer requires an employee to receive the vaccination from the employer or through a third party that we contract with and ask those screening questions, are those questions subject to the ADA standards? And their answer is yes. So by answering the question yes, they're essentially saying, yes, you can require it, but understand that if you're going to require the vaccines, that you're going to need to track and be careful about your ADA obligations in asking disability-related questions, and you need to be cautious about what you ask, how you document those things, and whether you should even be asking them as an employer yourself or contracting that out to a third party. But effectively, the EEOC is saying, yes, an employer can mandate that employees get vaccines if they choose to do so. It's another question that we'll talk about in a couple of minutes as to whether you should do that or you want to do that, because there are some risks and obligations that come with that mandated vaccine process. But at least they're telling employers generally across the country that that is something you could potentially do. The information from the EEOC also informed employers that when you are asking those type of disability-related screening questions to determine whether or not the information is job-related and consistent with business necessity, then it may depend in part on whether or not you're mandating the vaccines or getting that information or requiring it on, or sorry, not requiring it, but providing it on a voluntary basis. And understand that if an employee chooses not to answer questions related to this pre-screening, that you cannot retaliate against them for refusing to answer those questions. And then the EEOC went on to talk about if you are going to have mandatory vaccinations, then what are the employee's rights with respect to declining to be vaccinated. And the EEOC wants employers to recognize that employees have rights under the Americans with Disabilities Act to avoid being discriminated against based on a disability. So if an employee who is being told that they must get the vaccine responds with the fact that they believe that they should not get that vaccine because of disability-related concerns, that they believe that getting the vaccine would pose a threat to them, for example, then the employer would have an obligation to accommodate that employee's request and evaluate whether or not they should, in fact, require that employee to get the vaccine. So employees can request a reasonable accommodation, and the employer must then work through what's called an undue hardship evaluation before excluding the employee from the workplace. In addition to an employee objecting based on physical disability accommodation purpose, an employee could also object to getting the vaccine based on religious views. So if they have what the law calls a sincerely held religious belief, practice, or observance that prevents them from receiving the vaccination, then the employer is going to have to consider what reasonable accommodation they could utilize in order to recognize and respect that particular religious belief or practice. The employer, could also decide that it could be an undue hardship for them to accommodate that request. But generally, the EOC says that if an employee makes a legitimate objection based on religious belief, that the presumption basically is that the objection is well-founded, and the employer would have to work through what type of alternative arrangement they could make with that employee. An example might be that they allow the employee to work remotely, or they stagger shifts, or somehow make it so that that employee who is not vaccinated can still perform their job. So in terms of vaccinations in the workplace, then an employer is going to have to consider whether the vaccine is mandatory or voluntary. If the employee raises a disability accommodation issue, a religious accommodation issue, perhaps they have political views on the topic, maybe they have strongly held views about vaccinations in general, or there's just a general fear by the employee about getting the vaccine, and the employer is going to have to work through those issues with the employee as the vaccines continue to get rolled out. Some additional risks that an employer should take into account with respect to vaccinations is that an employee could contend, especially if the vaccine is mandated, that they suffered some type of adverse physical reaction to the vaccine. And if it's a mandated vaccine, that could become a workers' compensation claim. The National Labor Relations Act is a federal statute that primarily has to do with union management relations, but also applies to companies that are non-union, and protects employees who exercise what are called protected concerted activity rights, where an employee may come forward to express to an employer concerns about terms and working conditions on behalf of other employees. And if they're expressing those views on behalf of other employees, that might be considered protected concerted activity. If those concerns relate to vaccinations, then we would need to be careful about taking any type of adverse employment action against those employees by virtue of them having raised those concerns to us. An employer has to understand that even though they may be an at-will employer, that at-will employment doesn't guarantee that they can terminate an employee for any reason at any time. So even though that's what the law states in terms of the definition, there are circumstances where employees are protected by public policy concerns where the employer cannot terminate them even though they're at will. And so again, if an employee is raising issues, for example, that they need a religious accommodation, the employer's response cannot be, well, I'm an at-will employer and I can ignore your request, and I'm just going to let you go because you won't get the vaccine. So we're cautious about the limitations on at-will employment. And then some jurisdictions we may still see coming out, regulations regarding mandating vaccines, et cetera. We'll just have to continue to watch those issues as we go through. If you're a unionized workforce, then this is an issue you may have to work through with the union as well to decide how you're going to manage this. So recognizing that there are some risks and some uncertainty around this topic, employers should consider whether or not they want to mandate vaccines. They might want to consider encouraging employees to get the vaccines rather than mandating it, or perhaps implementing some type of system where they reward employees who get vaccinated, maybe bring the vaccine into the workplace to make it easier and thereby enhance the likelihood that more people will get vaccinated, maybe serve as a role model to get vaccinated by doing that yourself. All right, so I'm going to stop there and turn it back over to Jerry.
Okay, I had a minute to unmute myself there. Okay, thanks, Dan. So I just had a couple of things left to cover. I think, to be honest, they're of limited importance in this morning's context. The one I'll just hit on it real quick. A year ago, folks had some anxiety about the California Consumer Privacy Act that was there was an exemption put in for employers until January of 2021. That has been extended for another year until January 1, 2022. So we can all breathe a sigh of relief for that. We'll see what happens in the coming year if that gets extended once again. Workers' compensation, there are a couple of workers' compensation presumptions which you're probably aware of. What I will say about that, I don't want to get trapped in the weeds with this. If you have questions regarding presumptions of workers' compensation claims, they're really limited in terms of their applicability, in terms of who they apply to. Please feel free to give me a call. We only have 30 minutes left, and I want to give time to Dan to do the cases. So I'm happy to take your questions and phone calls about presumptions, disputable presumptions, and rebuttable presumptions in regards to the workers' comp system and who they apply to and how that may affect your place of employment. But I want to stop there and give the rest of the time to Dan to cover the cases we have to talk about for this year.
All right, very good. Thanks, Jerry. So we have a selection of different court decisions. As many of you know, there are court decisions published on a daily basis in California between California courts and federal courts that relate to employment issues. And so, we typically select a few of those that we believe might be a little more noteworthy to discuss with you. But literally there are hundreds and hundreds of cases that are published every year. And so I'm going to go through a couple of these that I selected out to discuss with you. In this first case, this Anthony versus Trax International Corporation. This was a Ninth Circuit case. It's a federal court case that, the Ninth Circuit has jurisdiction over the western part of the U.S. And in this instance, the Ninth Circuit was dealing with a technical writer who was fired from her job. And she was fired because she did not provide a release to work following an FMLA leave. And as Jerry mentioned earlier, with the California Family Rights Act, that is a leave that can provide employees with time off up to 12 weeks. The FMLA has an identical amount of time off, the 12 weeks. But after that 12 weeks has expired, then an employer still needs to consider whether it has any obligations to that employee to give them additional time off under the Americans with Disabilities Act or the Fair Employment and Housing Act as a form of reasonable accommodation. In this case, the technical writer who had completed her FMLA leave didn't provide a release to return to work. She didn't come back to work, nor would she provide a release to return to work. And so the employer ultimately said, well, then you're absent without leave, and we're going to have to terminate your employment. And so she sued, contending that the employer had violated the Americans with Disabilities Act by terminating her in that context. The employer said that, well, we didn't violate the ADA because you're not actually a qualified individual to obtain protection under the law. And the reason you're not a qualified individual is that you don't even have the required degree that you were supposed to have to even be serving in the position as a technical writer. And they only learned about this, the employer only learned about that after she was terminated. So it kind of fell under this idea of what we call after acquired evidence. But the court nonetheless found in favor of the employer and says that, in fact, she wasn't a qualified individual. She didn't meet the requirements for the job. And even though the employer didn't find out about that until post-termination, that was a sufficient basis for the employer to not return her to the job, and her ADA claim failed. So when we're dealing with these kind of issues as an employer in litigation, Jerry and I are often, looking at not only what is the information the employer had surrounding the termination itself, but we're also asking our clients, have you found out anything, post-termination that would have justified that termination if you had known about it while the employee was still working for you? And sometimes we can apply then that after acquired evidence doctrine to the defense of the litigation. In the Bostock versus Clayton County, Georgia case, this made the headlines because the U.S. Supreme Court decided last summer that Title VII of the Civil Rights Act, which is a federal statute, also covered and protected employees across the country based on sexual orientation or sexual identity. And so the issue in that case was whether the already standing protection under the Title VII for discrimination based on sex included those additional categories of sexual orientation or sexual identity. And the court said, yes, it does. This was a huge case on a national scale. Not as big a case for us in California, because we had already recognized for many years sexual orientation and sexual identity as protected statuses. But it is something that has broad impact across the country. In the Auto LLC versus Co case, the California Supreme Court was again looking at an employee's arbitration agreement. And we see decisions coming out from various courts in California, both at the federal level, the appellate court level, and the Supreme Court level, really almost on a monthly basis, if not even more frequent than that, related to arbitration agreements. And employers are using arbitration agreements in many ways to protect themselves against different types of litigation, including class action litigation, because an effective arbitration agreement could operate to preclude an employee from pursuing a class action claim against the employer, and also force an employee to proceed through arbitration rather than the jury trial system to address any disputes or concerns they may have about what their termination or how they were treated in the workplace. But those arbitration agreements are closely scrutinized by the courts to make sure that they are enforceable. And the court looks at the agreements oftentimes from both what's called a procedural unconscionability perspective and a substantive unconscionability perspective. And the agreement has to meet both standards, essentially. In this case, in the Auto versus Co case, the court found that the agreement was unconscionable and could not be enforced. And the circumstances under which the court was looking at it were such that they determined that newly hired employees were not provided the opportunity to review the arbitration agreement or to discuss it with a knowledgeable person. It was kind of a take it or leave it, sign it today, sign it along with the employee handbook. We need it back from you immediately. If they wanted an opportunity to review it, they weren't provided that opportunity. It was provided to them as a condition of employment. It included, this particular arbitration agreement included a forced waiver of participating in labor commissioner hearings. They weren't provided a copy. The agreement was written in very small font and was very dense and difficult to read. And the combination of both the way that it was rolled out, the difficulty in reading it, and some of those important clauses were in combination enough for the court to say, we're not going to enforce this arbitration agreement. With that said, courts do enforce arbitration agreements all the time. And so if you are considering, or if you have an arbitration agreement already, then it's something that you do want to have reviewed by competent employment counsel, so that you are hopefully rolling out an agreement and doing so in a manner that it will withstand any challenges on the basis of either procedural or substantive unconscionability, because they can be a very useful tool for employers in preventing and defending litigation. In the Oliver versus Konica Minolta case, the court was looking at whether or not the time that an employee spent driving from home to their first customer for the day, and then on the return trip back home from their last customer, and whether or not that was compensable time. The primary issue that the plaintiffs were arguing was that the employer required the technicians to use their personal vehicle and to carry tools necessary to perform the work of repairing copy machines and such in their personal vehicle. The plaintiffs contended that because they were required to carry their own tools to do the job, that essentially turned the commute time at the beginning and end of the day into compensable time, and they wanted to be paid for that. The court looked at the issue closely and concluded that in this instance, we're going to let the trial court sort this out. We're not going to make a final decision on it, but the court did say that just because an employee is required to carry tools didn't automatically make the commute time compensable, And the court looked at things like, even though the tools took up some space in the back of the car, so to speak, there was still room in most people's personal vehicle to transport family members and to use the vehicle for other things. And so it didn't completely consume the use of the vehicle. And therefore, the court was inclined to say that it was not compensable time. But this is an issue that you want to be careful about as an employer. Generally speaking, if you are requiring employees to use their personal vehicles, then you're going to need to make sure you're compensating them for the use of that vehicle. Jerry had mentioned earlier that the IRS reimbursement rate on mileage is now 56 cents this year. And so if an employee is using their personal vehicle for work-related purposes, then they should be reimbursed at least at that IRS rate, so that you make sure you're covering all the costs associated with that employee using that personal vehicle. In the Betancourt versus OS Restaurant case, the employers again got a pretty favorable outcome from a court of appeal, in that the issue was whether or not a plaintiff who proved that the employee did not get their rest and meal periods in accordance with the law could also recover penalties under Labor Code Section 203 and attorney's fees for those claims. And this court, the appellate court, concluded that the employee was not entitled to recover those penalties for waiting time or for the wage statement violations, the pay stub violations, because of non-compliance with rest or meal periods. And so this decision is good. It's on appeal to the California Supreme Court, so it's not basically final yet in the law. But if the California Supreme Court upholds this decision, it'll be very good for employers, because it will reduce the exposure that employers have with wage and hour litigation, including class action claims as well. It is a reminder, though, for employers to be sure that you are following California rules with respect to providing rest and meal periods to your employees, that you're documenting those meal periods in particular, and that you're tracking those things for your employees, so that if you are subject to litigation down the road, you have a good paper trail to demonstrate that you're not only providing your hourly or non-exempt employees with their meal periods, but you're doing it on time and providing those meal periods by the 5th hour of work. So still remains very important for you to be in compliance on those issues. In the Baraga versus 99 cents stores, this had to do with class actions. In this case, the question was whether or not the employee or the employer could try and prove or defeat, for that matter, a class action by use of declarations from employees. And in this instance, the Court of Appeal denied an employee's motion to strike the company's declarations after the employee claimed the declarations were required as a result of some type of systematic, I should say, use of coercive and deceptive meetings with the declarants. And so the court denied that effort and concluded that the employer's use of those declarations was appropriate in the circumstances. The David versus Queen of the Valley Medical Center case is important, not because of the facts specifically with this case, but as a reminder that a lot of employers are getting claims, particularly in class action claims, with respect to the employer's use of rounding practices in how they calculate an employee's wages that are due. So a rounding practice is one where an employer says, for example, if an employee clocks in at 5 minutes to 8, are they going to round that time forward to 8 o'clock to start compensation at 8 o'clock? Or similarly, if the employee clocks out 5 minutes early, are they going to round it forward to the half hour, for example, to pay the employee through that time period? So this idea of rounding time is very common among employers, but those systems have been challenged frequently in litigation, because the plaintiffs like to contend that the employer's rounding practices work against the employee more than they work against the employer. That, in other words, that they favor the employer, and employees are routinely getting deprived of compensation because of the rounding practices. California does, there are courts that have said that rounding practices are legal, but you do need to be very careful to make sure that how you implement that rounding practice is neutral on its face and it doesn't undercompensate the employee. And that's difficult to do because it is something you'd have to audit or measure periodically to make sure that the employee is benefiting as much as the employer is benefiting on a week in and week out basis. In this instance, the court said that the loss of 0.26% in compensation over the relevant time period was so low that it was statistically meaningless, and the court upheld the rounding policy. Some professionals take the position that in this day and age, with the ability to track employees' time using digital time clocks and electronic methods of tracking their time, that it doesn't really make as much sense these days to do rounding, and it's a safer practice just to pay by the minute. And sometimes you're going to overpay the employees, sometimes you'll underpay them, but basically you're going to be paying them 100% based on what they actually work. So that is something for employers to continue to keep in mind. In this Luna versus Hanson case, we were revisiting an issue that has come up a couple of times in the last few years. For employers who do background checks or credit checks or different types of information for either applicants or employees, they need to make sure they're following correctly the obligations under the Federal Fair Credit Reporting Act and also California's Investigative Consumer Reporting Act. And those statutes have specific language about what type of documentation must be given to the applicant, and in particular, before you can do the background check. And in the Gilbert case a couple of years ago, the court said that you can't combine your federal notice and your state notice, your California notice, in a single document, and you can't provide other information along with that information. You have to give them a specific standalone Federal Fair Credit Reporting Act document that informs them of their rights under that particular statute. It's got to be a standalone document. In the Luna case, the plaintiff attempted to extend that obligation under the Fair Credit Reporting Act with respect to other hiring documents. And so in this case, the company's practice with respect to prospective employees was to have them complete several documents regarding driving records. So they had to sign a disclosure form, an authorization form, et cetera. And the plaintiffs challenged that, saying that they really had to provide those sort of independently to the employee. But the court rejected that argument and concluded that the employer's practices were fine. Okay, so that was good news for the employer. All right, so I'm just going to run through then, sort of summarizing a lot of things that Jerry and I have talked about, some action items to consider for 2021 as we round this out, and then we'll be happy to take questions from all of you or answer any if there are any pending. But for these action items, starting with make sure you update or create, if you don't already have one, an employee handbook to address leave of absence changes. You are obligated to inform employees about their rights under the California Family Rights Act and under the FMLA if you have more than 50 employees. And the handbook is really one of the best tools you can use to make that happen. There are other policies and pieces of information, for example, unlawful harassment policy that you're obligated to tell your employees about, and the handbook is a good vehicle to do that. Make sure that you understand the California Family Rights Act, and also if you're have more than 50 employees, understand that it is going to change how you implement your FMLA policy. Create your COVID-19 prevention program. Begin thinking about how you're going to address vaccinations in the workplace. Establish a protocol for reporting COVID-19 exposures to your workers' compensation carrier. Establish a protocol for the notification requirements that Jerry and I talked about under 685 and SB 1159. If you have more than 100 employees, then get prepared for the submission of that new and rather onerous pay data information that California is now requiring. Look at the exempt status of your workers. You know, Jerry had mentioned that with minimum wage going up, then the minimum salary has to go up, and you need to really make sure those who you have classified as exempt employees truly are exempt. So this is a good opportunity to evaluate that as well. You know, generally comply with your minimum wage increase also. Review your handbooks for compliant meal, rest, and overtime policies. Look at your timekeeping methods and pay practices, both in terms of rounding non-productive time, for example. Are you capturing all the time the employee works? Are you making sure there is no off-the-clock work that is either allowed, you know, with the supervisor turning the other way and not making sure the employee is tracking all that time, and also that you're tracking your meal periods as well. Understand that the California law regarding exempt status is more stringent than the federal law. So even though federal law, you know, has its own requirements, make sure you're really complying with California's laws because they're more stringent. Are you meeting your sexual harassment training requirements that have continued in effect? If you have independent contractors or considering classifying someone as an independent contractor, then you be very careful about compliance with the ABC test under AB5. Evaluate whether or not you're going to allow FFCRA in 2021. As Jerry said, this is a good time to make that decision corporately as to whether or not you're going to voluntarily allow that type of leave in 2021. If you're an employer who hires minors, then make sure you understand your mandatory reporting requirements as an HR professional. Evaluate pay equity issues in your organization. So even if you don't have 100 employees or more, you're not required to report that pay band information to the Department of Fair Employment and Housing. It's still a good idea within any organization to make sure that you are paying employees fairly and properly based on gender, race, and other protected statuses. Check your expense reimbursement practices and whether you're using the IRS rates. Perform an overview of the exempt status of all your employees who you're paying a salary to. Update your posters. As Hillary said, those will be available in the next week or so and will be getting sent out to you. Understand that poster, which is a very important poster for employers to put up in their workplace, does not cover every single issue that needs to be posted. For example, you need to post the Industrial Welfare Commission orders that apply to you, and those aren't on that large poster because that varies from employer to employer. So you want to make sure you've addressed all your posting requirements. Look at your disability leave accommodation and interactive processes as you're dealing with individuals with a physical or mental disability, and then consider reviewing your insurance policies for adequate coverage, including whether you might want to consider what's called EPLI coverage, coverage that addresses employment law related claims. So that's a lot of information in a whirlwind fashion from Jerry and I. So I'm going to stop with that and then see if we have any questions. Do we have any pending, Hillary?
I don't see any. If anyone would like to ask their question live, we can go ahead and do that.
Very good. I know it's a lot to assimilate in a short time.
Daryl, did you have any further questions? He just typed in the chat. If you'd like to ask your questions live, you can use the hand emoji icon and I can unmute you. Elena's got a question. All right, Elena, you can ask your question. You just need to unmute yourself.
Okay, there you go. Thank you for all the information. That was great, by the way. I had we had a company switch over. Our old company was sold the 11/30, and a new company started December the 1st of 2020. So, and one of my employees called in sick, and she decided to have a baby. She never told anybody she was pregnant. We just thought she was getting heavy. So she had a baby, and how does that work for CIFRA or FMLA? Because she's only been employed here with the company for 6 weeks.
Well, if she's only been employed for 6 weeks, she would not qualify for any leave under FMLA. She could qualify for what's called the pregnancy disability leave, because that starts immediately upon employment. But to qualify for leave under pregnancy disability leave, she would have to notify you through her physician, like through a doctor's note or something, that she's actually disabled due to her pregnancy and needs some sort of time off due to a disability related to the pregnancy.
So I guess what happened is that she just went to the ER, and then she had the baby. Like I said, we didn't know she was pregnant. She never told any of us. And so now the baby's a preemie.
Okay.
So she has not contacted us since that happened.
Well, I would contact her and see what her status is and let her know that she doesn't qualify for any type of baby bonding leave because she hasn't been there for a long enough period of time. But if she notifies you that I'm not a woman, never had a baby, but I would just, my understanding is that, after a woman has a baby, she's going to be disabled for some period of time. I don't know how long ago the baby, maybe you said, and I missed it, how long ago the baby was actually born, but there's going to be some period of time.
She was born last Wednesday.
Oh yeah. Okay. So she's going to logically be disabled for some period of time after the birth.
Okay. So bottom line, she's only qualifies for the disability section, not the rest. Correct. Okay.
Correct. And
that's if and when the doctor only says that she's disabled because she had the baby.
I'm sorry, say that again.
That's if the doctor says she can't come back to work because she's disabled, because she's disabled.
Or needs an accommodation. Yeah.
Okay.
Right. Okay. Disability related to the birth.
Okay. Thank you.
Okay.
Thanks, Elena. And so we have Daryl has a question.
Hey guys, thank you again for having this little webinar. I had a question, again, Daryl Santos, local farmers insurance agent. With the EPLI, I definitely find it important. I haven't, fortunately, none of my clients had to file a claim on, regarding that coverage, but I was curious to know if you guys could share, some either some cases or some case studies regarding EPLI that you guys dealt with in the past, just so I could have some additional stories or examples for future business clients.
Well, I mean, I'll take a first stab at that. A lot of my clients do have EPLI coverage. Others don't. Of course, that's an individual decision for them to make, but it certainly has come in helpful, for clients who have the coverage when they do get sued, because the EPLI policies typically will cover the defense costs, the attorney's fees, as well as potential liability. Most EPLI policies have a what they call a retention or kind of a deductible, where the employer has to cover the first, X amount of fees and costs that and liability that are associated with the claim. That can range from $5,000 to $100,000. It just depends on the employer and the policy. So there typically is some money that comes out of the company's pocket, but it can provide some good coverage for an employer to protect them against a big hit, as well as covering attorney's fees. Most, in fact, I think all EPLI policies do not cover wage and hour claims. That's typically excluded from EPLI policies. There may be policies out there that I'm not aware of that cover that, but generally that's excluded. but some policies will still provide some coverage, at least for the defense costs, the attorney's fees and costs associated with defending a wage and hour claim, even though they don't cover the actual liability. In terms of specific examples, I don't know that I could, I mean, it's the coverage. I've had cases, covering a whole range of issues, from discrimination to wrongful termination to wage and hour claims, all types of discrimination, really, whether it's pregnancy or sexual harassment, race discrimination, that have from time to time been covered by your EPLI policy.
Yeah, I don't have
Thank
much
you.
to add to that.
Yeah, I was just kind of looking more for the topics of what you guys were experiencing. So again, you guys were sharing wrongful termination, discrimination, sexual harassment. Yeah, wonderful. Thank you.
All right, anyone else have any questions? No? Okay, well, thank you again so much, Jerry and Dan. We appreciate you providing these updates for us during these confusing times. Thanks again to Young Wooldridge and LeBeau Thielen for sponsoring our labor law series. And then I'll be sending out the link, since this was recorded, I'll send the link out to attendees for any follow-up questions. Please feel free to reach out to Jerry and Dan. Their contact information is on the first slide of this presentation that I'll send out again, that has Jerry's correct phone number. And then as soon as the chamber receives the labor law posters, we'll be sending those out to everyone. If you need additional ones, just, shoot me an email, let me know, and we can accommodate your request. Our mid-year update will be held in late June, so stay tuned for that announcement, and we can put that date on your calendar soon. And thanks again for attending today. I hope you all have a wonderful rest of your day. Thank you, guys.